Yes, Mr. Nariman, we would like to hear
May
you.
it please your Lordship, my Lord, I'm very much obliged for this opportunity to address you, my Lord. I would have really been delighted if I was there physically, but my Lord, there are all sorts of constraints. Otherwise, I would have not.
I know we would
It's
also
only
have liked you
because
to be
of your,
present here, but then
no, it's only because of your indulgence that you are, my Lord, able
something
to
is
give me
something
an
is better than
audience.
nothing.
My Lord, my Lord, the point that the learned solicitor has raised, my Lord, is important. I'm not saying it's not important. The questions that have been framed are also important because they would have a bearing ultimately on something to be decided in this case affecting the Sayedna judgment. There's no doubt about it. It would be so. But the point only is, my lord, today you have a writ petition of 1986 between a petitioner, the state, which is now redundant because the state was to support the act, but the act is repealed, and a private individual. Now, my lord, a tenor of decisions have said that such a writ petition is not maintainable at all. Now, whether you decide it now, you decide it later, you decide it after 9 judges, but at some point of time, that decision will have to be done in a pending matter because that is the only matter before you, containing a whole bundle of facts, a whole set of denials, lot of affidavits which I'm not bothering you with. Therefore, my lord, the question certainly can be referred, but nothing survives today in this petition, and that's for your consideration. Because although the act is repealed, the question of my right to excommunicate and the challenge to that survives does not enable the present writ petitioner to move under 32. That's for your lordship's consideration. There are judgments of your lordships specifically saying between private parties there cannot be an enforcement of the writ. Now, that's one of the considerations, whether you take it up now, whether you take, I'm not at the moment trying to short circuit anything, but take it up now, take it up later, but that question does arise, and it will arise later. And there is one solution to this, perhaps, following what the solicitor says, namely, in the Sabrimala case, it was contended before one of the dissenting judges, Justice Chandrachud, just as Mr. Nariman dissented, Justice Chandrachud also dissented. And the justice, that the Sayedna case should also be referred. And his lordship said, if your lordship turns to the Sabrimala judgment at page 180, para 272, 2019, 11 SCC, if you have got it with you, my lord.
Para 272 you are mentioning?
I'm obliged, my lord, at 180. This is the other dissent of Honorable Justice Chandrachud. And this lordship says, my lord, after discussing it at the bottom, just before 273.
This is concurring,
not decision in Saifuddin, he calls it Saifuddin, is the Sayedna case, is presently pending consideration before a larger bench. That is your lordship.
Yes.
Because this comes subsequent to the 5-judge bench judgment, my lord, which said that if you are convinced that the law laid down is wrong, then you refer it to 7. Lavot's judgment. So, my lords, quite frankly, this was all considered by the judges. It's not as if it's only it happens to be the other dissenting judge refers to it.
But in this opinion, Mr. Nariman, Justice Chandrachud's view was the
You was just same as Justice Nariman.
So it was the majority view. In this one, it's the majority.
Yes, it was the majority view, same as Justice Nariman and same as Chief Justice Deepak Mishra.
Concurring majority view.
This is the concurring majority view, 4:1, which went.
Absolutely correct. It's only Honorable Justice Indu Malhotra who took the dissenting view, which ultimately Justice Gogoi Malhotra thought was a correct view, and ultimately all those questions have
Everything is
arisen.
gone through, yes.
So there is no doubt these questions, the questions as framed by the 9-judge bench, I can't get away from it. It requires to be considered, and it will possibly be considered in God's good time. But today, my lord, what are we? We are faced with this problem. There's no question of referring anything. Your
So
lordships
Mr. Nariman,
Sorry.
we would like to have your response to a view canvas that since that 9 judges' judgment is awaited, instead of awaiting that, if on this practice of excommunication, a question is framed and also referred, the parties will have the opportunity to assist the 9 judges bench in respect of this particular nuance of the larger generic questions framed as the first two questions.
I don't think that would be a proper way of doing it, if your lordships don't mind my
No,
saying so.
I'm seeking your assistance and opinion as to what you feel about it.
Yes, I'm very much obliged. No, this matter comes because of Justice Lahoti's judgment.
Yes.
Because there were, in Sabrimala, this was contended. And Justice Chandrachud said, no, this is now before a 5-judge bench, let them decide whatever they want to do. And your lordships are now deciding what to do. And my suggestion, my lord, following the suggestion made, which I consider, my lord, quite reasonable of the solicitor, apart from the lists, etc., that just let this, my lord, stand over till the decision in the 9-judge bench, because all those questions, this question has to arise. There's no question of now framing another question and referring it again,
Okay.
because that occasion doesn't arise.
And anything else? Anything else, Mr. Nariman?
I'm sorry?
I said anything else you would like to say? I think.
Yes, I'm sorry. I would like to only say this, that as early as possible, a 9-judge bench should determine those questions, because they are all pending. No one can, my lord, gainsay that the 9-judge bench has dissolved. It's not dissolved. The 5 of the judges have retired, etc., but that makes no difference. Then there is an order of the 9-judge bench framing questions. So either they have to be answered, or, my lord, something has to be done about it. Now, and I have no doubt that the answer to that question will certainly help this honorable bench to determine the correct view to be taken on excommunication. There's no doubt, because you just see the questions. They are all the questions 2 and 4.
Yes, they have large generic question, but Nariman, on the lighter side, this is not in my hands.
Actually, just to, the matter was, in fact, the 9-judge bench was listed for 1 week of continuous hearing in 2020 March.
Yeah, but then COVID intervened.
Otherwise, it was fixed.
Only set for a day.
But unfortunately, because of that.
But initially that flu intervened. Swine flu intervened. 2 honorable judges comprising of the bench were infected.
Yes.
And thereafter, immediately COVID.
2 of us have gone through it. Yes.
Yeah, that's right. And then when we have never seen the light of day. But my lord,
Yes.
we would also like this question to be decided at the earliest. There's no doubt about it.
Understand.
Therefore, I suggest, my lord, that at the moment, if it's convenient, without raising any preliminary points, which I have, I'm not raising them at the moment. Let all of this be decided after the 9-judge bench formulates its answers to the questions. That's enough. Whether it decides the review in a one way or not, it makes no difference.
Okay. Thank you,
Just
Mr.
one,
No, just may I have 2 minutes.
Just 1 second. I gave you a chance. Now, what do you want to say in supplement?
There is one issue or one question which even
About my learned friend, sorry, my lord, to interrupt. Sorry to interrupt you. My learned friend who's just arguing, he's not connected with the Dawoodi Boras. It's another community from Gujarat.
That's a different community.